Hi, my name is Wes Zaba, and I am the managing attorney at Borland North and Zaba PC. I've been a real estate attorney for over 15 years and personally close over $60 million in transactions every year all over the Chicagoland area. Our firm releases instructional videos for brokers on a weekly basis, covering some of the legal issues facing buyers and sellers in the real estate industry. They are only about 3 to 5 minutes long, so we encourage you to subscribe below, and you will be notified when new videos are released. These videos are designed to further educate you and hopefully allow you to provide even better representation for your clients. In today's video, we will discuss and introduce the 8.0 contract, which is set to be released on February 1st. The contract committee, which does include an attorney from our firm, worked over 7 months to get this updated version completed. The committee was comprised of attorneys and brokers, and there was over 180 suggested updates and changes that were all considered. There are some substantive changes, as well as some reorganization to make the contract flow better. Some of these updates concern the legal language of the contract, which will impact attorneys more, and other changes that will affect how a broker completes the contract. If you haven't seen this new version of the contract yet, you certainly will soon. Today, I am going to go through the contract and discuss the major changes and how it impacts brokers, attorneys, buyers, and sellers. So let's get started. You should have a copy of the draft 8.0 contract in front of you, or if not, you can email me to receive one. Now let's take a look at the first page of the contract. Everyone always argues over what information should be contained on page 1 of the contract, but obviously not everything can be included. The first thing you will notice is the personal property section has been removed, and the closing date has been moved up to page 1. The committee felt the closing date was very important information and should be included on the first page of the contract. Next, if you look at the first highlighted section, you see that the type of property, single-family attached, single-family detached, or multi-unit, has been moved to its own line on line 11. This section was often overlooked or missed when brokers were filling out the contract, so the committee felt that putting it on its own line would bring more attention to it. You will also notice that the location of the home warranty line has been moved under the purchase price section, as home warranties do affect a seller's bottom line. But the most important thing on the first page is there was a section added to notate the seller's contribution to the buyer's brokerage compensation. As you all know, how real estate commissions are paid has changed greatly over the past year, and the contract has been revised so this information can be provided up front. In this section of the contract, brokers will include whether the seller will be compensating the buyer's brokerage, and if so, what the amount will be. The amount could be a specific dollar amount or a percentage of the purchase price. Well, those are all the changes on page 1 of the 8.0 contract. Let's go ahead and move on to page 2. As we move on to page 2 of the 8.0 contract, there are a few important changes to cover here as well. As you will see on the highlighted version of the contract, there are several new items added to the personal property section, such as freezer, sump pump battery backup, above-ground pool, video doorbell, etc. These items were added to reflect personal property more commonly found in today's homes, and there is a focus on smart equipment. Please note, central vac was removed since it is not used very often anymore. Next, if you look at line 61, you will notice that there was a line added for solar panels. If the property has solar panels, you will check this box and then complete section 34, which we will cover later. Finally, language was added on lines 81 through 90 to clarify what options are available under the financing contingency, depending on whether the buyer's financing has been rejected or additional time is needed for approval. The options were not as clear in the 7.0 contract, so the committee wanted to clarify the proper courses of action in either case. Page 3 does not contain any substantive changes, just minor changes, such as moving the homeowner's insurance and flood insurance sections to this page. So we will move on to page 4 next. On page 4, the only substantive change was that the real estate tax escrow paragraph, was relocated to under the proration section, here on line 154. This paragraph states that if real estate has been improved but has not been taxed for the full year yet, then 3% of the purchase price will be held in escrow until the exact amount of taxes is known. The committee felt that this subparagraph was too often ignored in the 7.0 contract when it was back in paragraph 23 and should belong under the proration section since the language here dealt with tax prorations anyway. Next, we'll move on to page 5, which does contain a significant amount of substantive changes. As we move forward with the 8.0 contract, we are now going to discuss pages 5 and 6 together. There is one very important section that carries over to page 6. So first of all inspection-related paragraphs have been relocated together in the new contract. If you look at paragraph 14, this is the new as-is paragraph with a better definition of what as-is means. If a contract is marked as is, there are 3 options below in paragraph 15 relating to the inspection. Please note, if the as-is paragraph is initialed and paragraph 15 is skipped, then the inspection is waived, as stated in lines 192 and 193. So if you are representing a buyer who plans to have an inspection, the proper subsection of paragraph 15 needs to be initialed. Now, let's take a look at those subparagraphs. Section 15A should be initialed if the buyer is waiving the inspection, such as in a teardown situation. Paragraph 15B should be initialed if the buyer is having an inspection performed and reserves the right to make inspection requests. And finally, 15C should be initialed if the buyer is having an inspection performed for their own knowledge, but does not have the right to make any inspection requests. Too often, under the 7.0 contract, a buyer would mark a contract as is in order to make a stronger offer, but then still make inspection requests during the inspection period. When I represent a seller with a 7.0 as-is contract, I probably get inspection requests about 80% of the time in those situations. It was happening way too often, so these last 2 subsections were broken out, so hopefully sellers will be aware of whether the buyer intends to put forth any inspection requests. Moving further down page 6, the wood-destroying insect and well and septic paragraphs were moved up to be included with the rest of the inspection paragraphs. There was also some minor language changes in there, extending the wood-destroying insect inspection to 15 business days and increasing the cost that triggers cancellation in line 259 to $5,000. Okay, that will wrap up pages 5 and 6, and there is no substantive changes to page 7, so we will now move on to page 8. On page 8 of the contract, there is a substantive change in paragraph 24. On the 7.0 contract, there were 4 lines the parties needed to initial, lines 297 to 303, that discussed unconfirmed special assessments, special service areas, and improvements to the property that hadn't been assessed yet. In the 8.0 contract, these same statements are included, but they were added to the seller representations under paragraph 24, so they no longer need to be initialed by the parties. Now, a couple things to note here. First, these representations do survive the closing, meaning that if a seller representation ends up being untrue, the buyer can pursue the seller for damages even after the closing has concluded. Second, as a result, it is now important as a listing agent to go through these representations with your client to ensure they are true and accurate to the best of the seller's knowledge in order to avoid any potential issues or litigation. That's the only substantive change on page 8. Now we will move on to page 9. On page 9, there is just one minor change. Paragraph 27 deals with directions and rules that an escrowee must abide by, and in subparagraph A, the language was changed to only apply to Illinois real estate brokerages in order to match the state statute. This section does not apply to non-brokerages holding earnest money since they are not covered by that same statute. We will now move on to page 10. On page 10, there was also just one substantive change made. Section 29 addresses the parties' performance under the contract and what can happen if litigation occurs related to this contract. More inclusive language was added, stating that this section applies to any action arising out of or related to this contract. This is meant to further protect each party. Page 11 does not have any significant changes, so we will now move on to page 12. Page 12 has a few important changes from the 7.0 contract. Paragraph 32 deals with the backup offers and when a new contract is contingent on the cancellation of a previous contract, such as when the buyer has a home sale contingency. Under this new section, in a situation where a buyer has a home sale contingency, the seller does not have to notify the previous purchaser of a new accepted offer until the attorney review and inspection periods are closed. This language protects the seller from terminating a contract with a home sale contingency only to have the new purchaser raise significant attorney review or inspection items, potentially leaving the seller without any buyers. Moving on, Section 34 addresses alternative energy, generally solar panels, which is a new paragraph altogether. If the alternative energy line is checked on the first page, this paragraph should be filled out. Brokers will have the parties initial this paragraph and then mark one of the three boxes, whether the seller owns the solar panels outright, whether they are owned but the seller is still subject to a financing agreement, or whether the solar panels are simply rented. Also, per line 522, the seller must provide all information and documentation related to the alternative energy within 3 business days after the date of acceptance. The seller then has 3 business days from receipt of this documentation to review it and can terminate the contract during that review period for any reason if that documentation is unacceptable. Finally, if the documentation provided by the seller is inconsistent with what is marked in this paragraph, the buyer can terminate the contract at any time. So as a listing agent, if your seller has solar panels on the property, it is important for you to encourage them to gather that documentation and provide it to the buyer's side as quickly as possible after acceptance. Now we will move on to page 13. Page 13 has just one change, and that is the addition of the contract addendum section. If you remember in the 7.0 contract, paragraph 37 was just a blank attachment section for parties to list what attachments apply, if any. Under the 8.0 contract, a section with actual named addendums was added, and the parties can just mark off any addendums that apply to the contract. Page 14 is just the signature page, which does not include any substantial changes, so that will wrap up our review of the 8.0. Again, this contract is scheduled to be released the beginning of February 2025, with both the 7.0 and 8.0 contracts being available for about a month, after which time the 7.0 will be removed. So it is important to familiarize yourself with this new 8.0 contract. If you have any questions related to the contract or anything else, you can contact me directly at the information on this page. I encourage all of you to use me as a resource if you run into any legal questions or issues. Again, our firm offers severely discounted attorney's fees. We represent sellers for just a flat fee of only $199 and purchasers starting at $399. I know most of you probably work with a specific attorney already, and I'm not asking you to abandon those relationships, but rather add us as another option for your clients, and I encourage you to give our firm a try. Not only do we offer discounted attorney's fees, but we also offer $500 off title fees for sellers, saving them almost $1,000 per closing. I hope you enjoyed this presentation and found it helpful, and I look forward to working with some of you very soon. Thank you.